Good evening, everyone. Welcome to Unacademy, the one-stop destination for the civil services English medium aspirants. Welcome to UCAN, Unacademy's Current Affairs Navigator program. What we intend to do here is to cover current affairs which have been in the news for the last 2 to 3 odd weeks. But this particular class is special because in these classes with me, which will be twice a month, you'd be covering 2 magazines. One Yojana and the other Kurukshetra. These are government publications, and sometimes the themes that have been covered in these magazines become very, very important for the examination. Before we begin and move further, I will also check the comment section and see if I am clearly audible and visible, and then we shall resume. Are we clearly audible and visible? Please let me know in the comment section. If everything is fine, we will begin. Perfect. All right. Okay. All right. Let's resume. Now, when we are doing these magazines for the exam, that is Yojana and Kurukshetra, there are a few things that we always have to keep in mind. What are those things? The simple disclaimer being that every word written in the magazine is not important and relevant for our exam as it is. Did you understand? So there are multiple articles, multiple chapters in the magazine, which is 50 odd pages, but everything written in it is not important. That is why it is our job, my job, to extract only the relevant portions of this magazine and present it in front of you for strictly the examination point of view. Yes, so the examination point of view will require us to also change the chapters a little bit, add a little more and extra to the chapters, and make sure that at least when we are going back after this lesson, we are covering certain important themes and not just small scattered topics in the magazine. Yes, so allow me to make a few changes to the magazine so that you can go in or you can go back with a proper theme that you have already done, finished and understood in this session. Please stay with me because it's a very, very important topic. Our constitution and legal reforms. A lot of this is going to be important and relevant for GS paper 2. Let's discuss the themes now. 75. Now these are the themes that I would be covering in today's lecture. 75 years of Indian Constitution, the Indian Constitution. What has been the judiciary's role per se? When I'm discussing this, I will tell you why this has been a repeated theme in GS paper 2 as well. Second topic, evolution of the Indian Constitution. How has it evolved? How has it changed? And of course, when we're talking about the evolution, we also have to figure out and check amendments per se, also directly written in GS paper 2. Third, role of Indian Constitution in promoting social justice. A very, very direct theme from GS paper 2, which is revolving around what are the steps, what are the constitutional provisions, laws, policies, etc. for the upliftment of the vulnerable sections, GS paper 2. Third, redefining law in cyber age. Interesting topic indeed, because it can be asked in GS paper 2 or GS paper 3. How in GS paper 3 there was a focus on the Data Protection Act that was asked in this year itself. Therefore, a general question can be about how technological advancements are happening and how laws per se are they synced, or are they the technological advancement, are they outpacing the change in regulation? Do we have a regulatory vacuum in that capacity? So these become important, and for mains enrichment we'll also do just brief about the BNS, which has replaced the IPC, Indian Penal Code, and a few new introductory offenses that have been added and what extra is particularly important in BNS. Also asked in GS paper 4 this year in mains. So all in all, what I'm trying to say is today's class becomes extremely important Please be patient and stick with me till the end. I will make sure that you understand very important concepts and take a lot of mains enrichment pointers as well. Okay, let's begin with our first topic as we had discussed. First topic. Now, the first topic being that when we talk about the 75 years to our constitution, in this duration, what has been the role of the judiciary per se, the role of the judiciary to ensure that the constitution has been a success over these years. What do you mean it has been a success? That it has stayed relevant per se in these 75 odd years. So the judiciary's role in the success of the constitution and the judiciary's role in terms of interpretation of the constitution in a light that reflects the current social realities. Okay, so that becomes important in that context. Why is this topic important? Let's trace it back to GS paper 2. This is important because judiciary or judicial review per se has been a recurrent theme that was asked in GS paper 2 in the context of separation of powers. Separation of powers between the judiciary, the executive and the legislature, which is why judicial review has been a recurrent theme in GS paper 2. This has also been asked in the context of prelims. If you would remember previous year questions, in prelims there was a question on who is the custodian of the constitution, and the answer was the Supreme Court of India. So who is the custodian of the constitution? The answer is Supreme Court of India. So the judiciary acting as a custodian, the judiciary acting as a guardian against any violation of fundamental rights, which can be of course challenged under Article 32. Yes, so a guardian of the fundamental rights of the citizen, a custodian of the constitution and the final interpreter of the constitution. That means it is going to be the last word of the judiciary when it comes to how do you analyze what is written in the constitution. Please understand, the constitution is a document. So the constitution is a document. Have you ever wondered why is it called a living document? Why is it called a living document? A living document means a document that is particularly changing with times, that is incorporating the needs of the present times, that can be having some amount of dynamism per se. Something which is not static is something that we understand as living. So there are two things that contribute to the constitution being a living document. First, that is, it allows for amendments. That is done by the legislature, the parliament. And the second is that it allows for certain interpretations. The scope of the constitution is not limited to the simple text that is in the constitution. The judiciary can interpret the scope of the constitution, the provisions, and can expand its meaning. One successful example being the Menaka Gandhi case versus Union of India, where the Supreme Court had expanded the definition or scope of Article 21, and amendments of course done by the Parliament, which is why we call it a living document, because it can accommodate these changes. It does not cease to become relevant. It is continuously important and relevant with the changing times. If it was very rigid, if it could not be interpreted, it would have become redundant, which is why it is a living document. Yes. So this is why the judiciary's role when it comes to interpretation, etc., is very important. to ensure that the constitution, the constitutionalism per se is upheld, as well as the ideals of the constitution are generally followed in all the judgments that it particularly gives. Let's understand what the judiciary's role per se is. Let's understand the judiciary's role. So first and foremost, what the judiciary maintains is that it creates a balance between what? Between ensuring that the core principles, the main fundamental values of the constitution, for example democracy, for example separation of power, for example rule of law, etc., they are always upheld, they are maintained even while the changes are occurring, as well as ensuring some amount of dynamism. So that is the role of the judiciary, to create this balance between ensuring that the core principles are safeguarded and also ensuring certain amendments and changes are possible in the vigilance of the judiciary. Therefore we come to the first thing, that what does it ensure and how does it do that? Using the powers of judicial review. Have you heard this term? A lot of mains questions have been around judicial review in the bigger context of separation of powers. Under judicial review, the courts or the higher judiciary have the power to examine if a particular law, if a particular constitutional amendment violates the provisions of the constitution, violates the fundamental rights, and therefore they have the ability to strike it down. So examine the validity of law in the lens of constitutional ideals. Yes, it is absolutely important. Judicial review is absolutely important to ensure what? To ensure fundamental rights are upheld, the guarantees of freedom that is enshrined in the constitution for the citizens, they are upheld, to ensure that the powers of the executive as well as the legislature do not become arbitrary. That means the scope in which the legislature is performing, the scope in which the executive is governing, should be always according to a rule of law. The same rule applies to them. Yes, so in order to halt or in order to control arbitrary power is power which is not defined by rule of law, power that is not defined by a constitution per se. Yes, and therefore by doing this, it ensures, it upholds the primacy of rule of law. So that is the function of the judiciary, and this is how it maintains it. What is it achieving using that? It is achieving separation of powers, that no one organ of the state, the legislature or executive, becomes all powerful. No one member or organ of the state becomes all powerful to the point that they can particularly not rule according to the constitution. That is something that they prevent per se. And it also ensures the supremacy. Supremacy of what? Supremacy of the constitution, and ensure constitutionalism. Please understand, this concept is also asked in your PYQs. That what do you understand by constitutionalism? Constitutionalism simply will mean that any government of the day, any legislature, executive, etc. of the day will be governed by the rule of law, will be governed by a set law or the supreme law of the land, that is the constitution. Unlike the UK Parliament, unlike the British Parliament, we do not have parliamentary supremacy, but we have the constitutional supremacy. Whichever organ of the government will get its power, they will derive its power from the constitution and nothing else. This is something that the judiciary maintains and ensures that this kind of a setup continues in the country. Yes, the second important contribution is it expands the scope of the fundamental rights, as we had already done. Now please understand, a constitution, even the lengthiest constitution in the world, which is ours, has limitation. It cannot be an exhaustive document. Therefore, the judiciary's role is to interpret what has been solidified and written in the constitution, which is why time and again we have seen that the judiciary in successive judgments had made sure that they have expanded the definition of fundamental rights in part 3. One example being the Menaka Gandhi versus Union of India case, in which the Supreme Court expanded the definition of Article 21 and said right to life does not mean simple existence, but it incorporates various other things such as right to health, such as right to a clean environment, such as life with dignity, so on and so forth. And therefore, this is an important example. Next example that you can possibly give is the Puttaswamy judgment, the KS Puttaswamy judgment, enhancing the right to life and liberty to also mean or to incorporate the right of privacy in it. What you are doing in your own four walls is a matter of your privacy, and that should be protected at all costs. The state should not intervene, the other individuals should not intervene in the same. Yes, so in the Puttaswamy judgment, right to privacy was recognized under Article 21. Yes, so this becomes important in that case. Yes. Next, how does the judiciary help in ensuring that the constitutional values are upheld per se? Is using the mechanism of judicial activism or using the tools of public interest litigation. What does this mean? Now, there are areas where the state in the form of the legislature has not brought about any legislation per se. There are areas where gaps exist. There are areas where legislative vacuum is witnessed per se. A classic example of this is the Vishakha guidelines. That is where the judiciary fills in, keeping in mind the constitutional ideals. What would the constitution want? The constitution is based on the ideals of equality. The constitution is based on the idea of dignity. The constitution is based on the idea of ability to freely profess or freely practice a profession. Yes, so because a woman's rights are violated if she is harassed at a workplace, because of that, the Supreme Court, based on the ideals, based on the philosophy of the Constitution, published or released certain guidelines called the Vishakha guidelines. Why is that the case? In this, what is the Supreme Court doing? They are ensuring that wherever there is a legislative vacuum. What do you mean by legislative vacuum? That there is no law in place. There are no provisions in place. The legislature has not particularly focused on that area. Gaps exist in that area. It is there where the Supreme Court or the courts will fill in. And therefore, one example become your Vishakha guidelines, in order to prevent sexual harassment at workplace. And therefore, this was followed by the enactment of the Prevention of Sexual Harassment at Workplace Act later on. So this becomes important. Another example, please understand, even PIL, the tool of public interest litigation, the role of judiciary, etc., was asked even this year in Mains 2024 in GS2. So another example also becomes the MC Mehta judgment, the MC Mehta versus Union of India judgment, where the Supreme Court had also filled in an area where there was not a lot of focus and gave guidelines for environment protection. And this also becomes a important role. Yes, what other roles that does the Supreme Court or the judiciary play to ensure that the Constitution is a success, it survives, and the constitutional ideals and basic structure are protected. The next role is to ensure that it upholds democracy, prevents the subverting of democracy, and also ensuring that federalism as a basic feature of the constitution is upheld. How does the Supreme Court do that? The Supreme Court intervenes in a lot of the center and state related conflicts. It is called the federal court, yes, and therefore so many times if there is an instance, if there is an event of misuse of certain unitary central powers. For example, there were instances where the president's rule was often used and often sometimes allegedly misused in order to bring down democratically elected governments in the state, just on the pretext of certain disturbances in the state, so on and so forth. And therefore the Supreme Court in the S.R. Bomai versus Union of India case spoke about certain safeguards, certain important safeguards, certain guidelines to prevent the misuse of the application of President's rule under Article 356. Don't you think this is a particular step toward protecting the states even against the center and upholding the federal spirit per se? Also upholding democracy. Those state governments are democratically elected. They should not be dissolved only on the possible misuse of a provision in the constitution. So even though a constitution provision existed, the courts ensured that if it is getting misused, we will step in and we will add certain safeguards to prevent the same. We will ensure that the earlier vision of the constitution makers, the intent of the constitution makers is followed through and through. Did you understand this point? Yes. Next, and a very important point, is by ensuring constitutional morality. This has also been asked in GS paper 2 mains as a previous year question. Now please understand, simple. What do you mean by morality? Morality is a definition where a group of people in a certain culture, in a certain area, they think something on the basis of certain reasons, they feel something is right or something is wrong. So a judgment of what is right and what is wrong is morality. That few acts according to them are correct and few acts according to them are wrong per se. Morality can be defined by various reasons. For example, if your religion is telling you what is right and what is wrong, if your family upbringing, your socialization is influencing your decision of right and wrong, yes. So morality can be influenced by many ways, yes. Constitutional morality means that morality, what is right and wrong, should be influenced by constitutional ideals and values enshrined in it, such as values of equality, such as values of preserving human dignity, such as values of preserving liberty, such as values of ensuring justice, social, economic, political. So these are constitutional values, and therefore what is right and what is wrong should be decided from the lens of these values per se. That is precisely what the courts have been doing in the last few years, that they are going way ahead and they are saying, even if directly it is not written in the text, and this is what you'll do in ethics as well. One is a direct link, one is a actual text which is just limited to the actual meaning of it, and one is the intention behind that text. So what the courts are doing, they are thinking about the philosophy of the constitution. What is enshrined in the preamble? What do we aim to achieve? Which kind of a society do we want to bring in? And on the basis of those constitutional ideals, they are giving a judgment about what is right and what is wrong. A classic example being homosexuality. According to many religions, and a lot of conservative sections, can be considered as an immoral act. Yes, according to those sections. And therefore, the Supreme Court did not restrict their understanding of it on the basis of religion, on the basis of certain sections, on the basis of a minority opinion or a majority opinion. They basically saw this case of criminalizing homosexuality to see it as a denial of equal rights to the particular section. Discrimination on the basis of your sexual inclination as a denial of right to equality. They should be treated with the same amount of dignity. Yes, and therefore on the basis of those constitutional ideals, morality of what is right and what is wrong was decided. And that is why you have the Navtej Singh Johar versus Union of India case, in which the Supreme Court decriminalized homosexuality. Are you understanding? So this is where they interpreted a judgment on the basis of constitutional ideals, values, principles such as equality, such as dignity, such as ensuring justice. And this is what helps in progress of a particular society. Yes, another example of this is according to personal laws, according to religious beliefs, according to personal laws, triple talaq was considered maybe moral according to a certain section of the society. But the Supreme Court said that when we put it to the test of constitutional morality, when we put it to the test of constitutional ideals in a modern day society, we realize that this is severely against gender justice. It is discrimination against a woman. It is not treating the woman equally in a marriage. Yes, and therefore we have the Shaira Bano case as well. The Shaira Bano case is something that you can talk about, banning triple talaq. So these become your constitutional morality arguments. Simply, morality not defined by religion, morality not defined by communitarian arguments, morality not defined by the belief of the majority, but morality defined on modern ideals, humanitarian ideals such as equality, dignity, justice, liberty, so on and so forth. Yes, therefore increasing the scope through which the constitution makers, their vision can be implemented even in today's time. That is how the role of the judiciary is. Of course, now, last but not the least is using the basic structure. Using the basic structure, the judiciary has ensured that a balance can be created by giving, they are allowing the parliament, because it is a democratically elected body, to change a substantial part of the constitution because they enjoy people's mandate. Yet ensuring that the core of the constitution, the main values of the constitution are never amended in this process. The basic structure doctrine, which was of course talked about, or which was created in the Keshwananda Bharati judgment in 1973. Yes, so these are all the examples that you can write. These are cases which are important. At least remember the names of these very cases. I'm only giving you the very important ones and what was the judgment like. And try to use these cases in the points where you are writing about the judiciary's role per se. Yes. Now, If this is clear, let's attempt a question and then we'll come to the next topic. It's an MCQ. Please attempt it. I will not be able to start a poll, but I will also be seeing your answers in the comment section. So try to attempt it with all honesty. Do not see your previous poll comment and use your particular knowledge for the same. Consider the following statements. I'll be giving about 60 seconds in the poll. "60 seconds in the poll, please. Then I'll discuss the question. Please participate in the poll. All right, let's discuss this. Consider the following statements. I'm coming to the second topic. So before that, I wanted this question. Consider the following statements. A constitutional amendment bill can be introduced both by a minister as well as a private member. That means any MP in the houses. The answer is yes. A constitutional amendment bill can be introduced both by a minister as well as a private member. No problem with that. The restriction of an MP or a minister only introducing the bill is not there. That is why first statement becomes correct. Let's talk about the second statement. The constitutional amendment bill involving changes to the federal structure must be passed in at least half of the state legislatures with a special majority. What is the problem with this statement? The only problem with this statement is, yes, if there is a constitutional amendment bill which is affecting the federal structure, for example, if it is amending the 7th schedule, the 7th schedule has the concurrent list, the state list and the central list, yes. So if it is changing the jurisdiction or if it is involving any change in the powers of the center vis-a-vis the states, in that case, the opinion of the states or the ratification of the states will be required. Why? Because you're making an amendment in that area that is affecting their power. You're maybe changing a subject in the 7th schedule in which they have any amount of jurisdiction, and therefore their opinion should be sought. Their opinion should be taken. So that's the simple logic, that if an amendment involves the change in a federal structure, can you give me a classic example? The classic example is the 101st constitutional amendment that is relating to goods and services tax, the GST. That required ratification by the state legislatures as well. But the problem with that statement is that yes, it has to be passed by half of the state legislatures at least, but not by a special majority, but by a simple majority. So in the states, it has to be passed only by a simple majority. That is why the second statement becomes incorrect. Okay. Third statement. The president can give assent or reject a constitutional amendment bill but cannot return it to the houses. Please note that the only possible choice that the president has when it comes to the constitutional amendment bill is to give assent to it. No other choice. The president cannot reject it, nor can the president send it back. Is this clear? So the only choice with the president when it comes to the constitutional amendment bill is has to give assent. There is no other choice. Just one choice is something that you have to clearly remember. What about the third statement? In case of a disagreement, now when you talk about an ordinary bill, in case of a disagreement, you can have a joint sitting of the parliament with the Rajya Sabha and the Lok Sabha for the passage of the bill. But when it comes to the disagreement on a constitutional amendment bill, there is no provision of a joint sitting. No provision. It has to be separately passed in both the houses. Clear about this? That is why statement 4 is absolutely correct. Okay. So your answer becomes D, 1 and 4 only. D, that is 1 and 4 only. Is this understood? Yes. Next. Now let's come to our second topic. We are done with the first topic. Let's come to the second topic. This is something that we have done, judiciary's role. We are coming to the second topic now, evolution. How has the Indian constitution evolved and what has been the role of amendments per se in this evolution, in this progression. Clear? So let's come to the second topic now. Second topic. Before we do the second topic, simple. Article 368. What is the procedure? The procedure to amend the constitution is given under Article 368 of the constitution. There are 3 ways to amend the constitution. The first way is using a simple majority. Simple majority. Articles like changing, reorganizing certain states, reorganizing the area of a state, admission of new states, etc. Articles 2, Article 3, etc. can be done using a simple majority. Yes. The second way is by a special majority. Special majority is one requiring 2/3. Yes. So majority of the constitution is amended using the special majority in both houses. And the third type of amendment we have already done, relating to a change in the federal structure, will use a special majority in the 2 houses. Along with this, it will require more than 50% of the state's ratification. So these are the 3 types of amendments to the constitution under Article 368. This is the procedure. Please understand, this is very, very important even for your mains topic GS paper 2. It has also been asked what are the ways to amend the constitution, and in the features of constitution written in the syllabus, amendment is directly written, which is why this particular topic becomes important. So there are 3 ways to change the constitution. The procedure is something that we have done. Now, let's understand what are the 2 arguments that we need to do for mains per se. The first argument is, should Parliament be given enough powers to change the constitution? One side. The second argument is, should the Parliament's power, that is the legislature's power, be restricted or limited beyond a certain level? These are the 2 arguments that we will understand. So in amendment, what we are doing is that when you talk about the amendability of the constitution, how much power should the Parliament enjoy, the legislature enjoy, and why are there problems with excessive powers given to the legislature? Why is there a need to also restrict the excessive powers enjoyed by the Parliament? So these are the 2 arguments that become important for a mains related discussion. Is this clear? Yes. Now, so using this, what we want is, we want to ensure a blend between flexibility, that the constitution should be flexible to ensure that it is responding to the changing times, but the constitution should also be rigid to ensure that rule of law prevails and no organ of the state becomes authoritative, totalitarian. Yes, so a blend or a balance is absolutely needed in this particular light. Yes, so let's get into the two arguments per se. The first argument that we'll say is that yes, Parliament, it is significant for the Parliament to have the power to amend. Yes, and the other argument says that the Parliament's power should be restricted. That is the argument. Let's discuss this now. Okay, first things first. Why should the Parliament have enough powers to amend the constitution? It is on the simple logic that constitution is the supreme law of the land, is the supreme law of the land. Any law that is governing the people should have the validity by the people, should encompass, should incorporate the aspirations of the people, should in a way reflect the needs of the people, the opinion of the people. That is the simple logic on which democracy is resting, that people are electing their representatives in the form of MPs, and those representatives are making laws which in turn are governing the citizens. So the citizens have the right to make those decisions of how they want to be governed. That is simple democratic mandate, the basis of democracy, the essence of democracy. Yes, and therefore Parliament, being the representative institution, legislature being the representative institutions of the citizens of India, should have constituent powers, should have powers to amend the constitution, and therefore ensure that the constitution is constantly reflecting the aspirations of the citizens. That is point number one. So point number one becomes democratic mandate enjoyed by the Parliament or the legislature, which must reflect or which reflects the will of the people who are governed. Will of the people who are governed. Yes or no? Even in the preamble we say, we the people of India. That means the constitution is getting its powers. The constitution is legitimized because it is we the people of India give to ourselves. Therefore, if the people are entrusting their powers in the Parliament should have the power to amend the constitution. That is point number one. Yes. The second point is that it should reflect the changing. It should be flexible. Why should it have the power? Because flexibility will ensure that it is particularly reflecting the concerns of the society that is constantly evolving. A society is not constant, it is dynamic. There might be certain issues that want to be incorporated later on. So the constitution must give the flexibility to the Parliament to ensure that the changes in the society are incorporated, the aspirations of the people are addressed when it comes to the constitution. Yes, so that becomes important. Next argument is that some areas after the Constituent Assembly, who is considered supreme? This is not the case in India, but to ensure parliamentary supremacy. The argument that judiciary should not have the power to interpret, judiciary should not have the power to stop the Parliament from making the changes. So parliamentary supremacy, since law making is the domain of legislature. That becomes an argument. Next argument becomes that Parliament has not always, the concern that we have that the Parliament can misuse this amending power. We have seen that the Parliament in a lot of instances has also used this power for a good objective, to bring in constitutional reforms per se. And if they did not have the power to do so, they would have not brought in these reforms. So certain progressive reforms can also be brought about with the power of amendment. Some examples are the 73rd and 74th Constitutional Amendment Act of 1992, ensuring that democracy is decentralized. What do you mean by decentralized? That Panchayati Raj institutions, local bodies, etc. Now, representation of people's will should not be limited to the state legislative assemblies or the parliament. Their representatives can be in their close vicinity in the form of Panchayati Raj institutions and local bodies. So therefore, progressive reforms are also important with amendments. Yes, last but not the least, to balance power. What do you mean by balance power? The whole importance, the whole essence of separation of powers is that Parliament is ensured, is given the responsibility of making laws. So even though the judiciary can examine if that law violates the constitution or not, or violates fundamental rights or not, the power of the Parliament in the first place should not be curtailed. Yes. Now let's talk about the important part, which is the idea today, that Parliament's power exists. They can, and this was in the Keshwananda Bharati. A simple brief is that with the Shankari Prasad case and the Sajjan Singh case, they said the parliament can change any part of the constitution. Yes, but with the Golaknath case, they restricted. In the judgment, the Supreme Court said that the Parliament cannot change or cannot amend the fundamental rights. This was of course challenged. This was tried to be reversed by the Parliament, and therefore finally in the Keshwananda Bharati case, the Supreme Court ruled that the Parliament can change, amend any part of the Constitution, even fundamental rights, as long as it's not changing the core values of the Constitution, that is the basic structure. And who will define the basic structure? The court said that we ourselves, with successive judgments, will define the basic structure. Yes. So therefore, in this part, we have seen that this is the case in India, that Parliament has the power, but the power is also restricted. It is along with certain checks and balances by the judiciary. So first things first, why this should be restricted? To ensure that the basic structure, the core ideals of the constituent makers, they are not changed. For example, democracy is part of the basic structure. Rule of law should be part of the basic structure. The federal character of Indian polity should be part of the basic structure. So these are certain important ideals on the basis of which we have our systems of power, we have our systems of running the government. They cannot particularly change. That's what the court said. And therefore, it is important to restrict that power as well. Yes. So therefore, it is important for the judiciary to examine the laws, the amendments. Yes, and create a balance. Next things, constitutionalism. In India, we have the supremacy of the constitution. Constitutionalism means that even the citizens are protected against the excesses of the state. The state cannot be all powerful. The state cannot act in an arbitrary manner. the state is also defined, the powers of the states are defined, the functions of the state are defined, and they cannot surpass this power per se. Their rule particularly, their governance particularly is defined by certain constitutional rules, by rule of law. That is the basis of constitutionalism. Where you do not have constitutionalism, you have monarchy, or you have parliamentary supremacy per se, where anything can be done by the ruling executives, where anything can be done by the government of the day. But here in India, even if you have a certain majority, even if you have a majority in the parliament and the Lok Sabha, etc., there are certain functions, there are certain features of the constitution that you cannot possibly change. So that is the idea of constitutionalism or constitutional supremacy. This is very, very important, since it guarantees or it protects the citizens against the excessive powers of the party or the government in power. Yes, it also becomes important. It also becomes important to check majoritarianism. What do you mean by majoritarianism? That if there is a party in power which has the utmost majority to change and make any kind of changes to the constitution, this can lead to major issues for the minority rights per se. Yes, it can impose the rule of the majority if they have the numbers, just the numbers, to change the constitution without any restriction, without the restriction of the courts. Then it is important to check majoritarianism in order to protect the minority rights per se. So that is why you got to restrict the power of the parliament. It also is important to restrict the parliament's power to amend to protect the federal structure. Did you see how they made it difficult? In the procedure part, why is it difficult? This kind of change, this kind of amendment is difficult. It needs the opinion of the states. It needs the ratification of the state, because federalism is a basic feature. Before the center is changing any power which is related to the state, or any subject that is in which the states have an interest, in that case the state ratification is needed, so that we do not change our federal structure into a very unitary form of government, so that center does not become extremely authoritative and totalitarian. Yes, so it is important to maintain the federal structure, and that is why we need to restrict the powers of the parliament. Yes, and last but not the least, but to ensure stability. If amendability of the constitution is very easy, then you will have a lot of hasty amendment per se. It will lead to constant changes in law, constant changes in the constitution, and that might create a problem of stability of governance in the country. And therefore, some parts of the constitution must also be rigid per se. Yes, so these are the arguments that you give when you talk about amendability. Certain important amendments is something that we'll particularly do. But before that, I need you to attempt a question. This topic is over. I'll just give you some mains enrichment pointers about the main important amendments after this question, and then we'll move to the next topic. Consider the following statements. The term cabinet was not mentioned in the original constitution enacted in 1950. The term cabinet has been inserted by the 42nd Constitutional Amendment Act in Article 352. A limit on the number of Council of Ministers was imposed by the 52nd Constitutional Amendment Act to counter political defections. Please attempt this and then we will discuss it. I'll look at the comment section to see your response and then we will discuss this. Please attempt this in the comment section. everyone? All right, let me discuss this question now. The term cabinet was not mentioned in the original constitution. This statement is absolutely correct. The original constitution that was enacted in 1950 did not have the term cabinet mentioned in it. Clear? So first statement is absolutely correct. The second statement, the term cabinet was inserted by the 42nd Constitutional Amendment Act in Article 352. Please understand, Article 352 is relating to the proclamation of national emergency. Yes? And if we see the constitutional amendments, we at least have a basic idea that the 42nd constitutional amendment is associated with increasing the power of the prime minister and subverting the powers of the president. That the president must act on the aid and advice. That is relating to the 42nd constitutional amendment to increase the power of the government, of the legislature and the executive. While the 44th constitutional amendment, that was after the emergency period by the Janta government, was to bring about safeguards. Yes? So 44th constitutional amendment ensured that it provided for adequate safeguards so that the proclamation of emergency cannot be only on the basis of the prime minister's words per se to the president. Clear? I'll tell you this in a lot of detail. So to proclaim emergency under Article 352, national emergency, before the 44th Constitutional Amendment Act, the Prime Minister could tell the President to make that proclamation, could request the President to make that proclamation. Yes. After the 44th Constitutional Amendment Act, this wanted to be changed. They wanted to safeguard. They said only the advice of the Prime Minister should not be taken. This leads to a lot of authoritative behavior. Of course, we were just out of our emergency time and therefore certain safeguards were required. Certain other extra precautions were required so that this provision cannot very easily be used. National emergency has consequences of a very, very magnanimous, of a very large nature, and therefore it should be the written advice. Now what it said, that we need a written statement by the cabinet that should be sent to the president to declare a national emergency. So they added certain safeguards in that way. Just the Prime Minister's word, when you talk about aid and advice the president, just the Prime Minister's words alone should not be enough to proclaim a national emergency, which is something of a very grave matter. Something that can lead to huge consequences, enormous consequences, and therefore we have to secure and we need to make sure that the whole cabinet is taken into confidence and a written statement is given by the cabinet to the president, and that is why by the 44th Constitutional Amendment Act, to ensure more safeguards, it was added. So this statement becomes incorrect because here it is written 42nd, but the answer is 44th Constitutional Amendment. Is this clear? The third is, a limit on the number of Council of Ministers was imposed by the 52nd Constitutional Amendment Act to counter political defections. Now, 52nd Constitutional Amendment Act is associated with the 10th schedule. It is associated with the anti-defection law, but this particular provision, please understand, and how will this lead to lessening of defections, I will also tell you. If you have a Council of Ministers, if there is a government in place, that has a council of ministers per se, okay? The CM has his own or her own council of ministers, and they feel that they might lose the confidence of the house in the near future. Now, what is it that you can offer to make sure that party MLAs of a different party defect from their party and come and give you their vote of confidence? They come and join your party. How would you ensure that? By promising them certain ministerial berths, by promising them ministerial positions. So in the lure of ministerial positions is a way to attract defection. Is this not the case? So it is a pull factor to attract defections. And if we do not put a limit to this, so even if my council of ministers was a certain number, if 10 people or 20 people were in my council of ministers, I can keep expanding this just to make sure that everyone is defecting from the other party. If there is no limit, I can have 40 odd council of ministers, I can have 50 odd council of ministers, so on and so forth. You cannot have the whole legislature to become the council of ministers, the whole party. Yes. So there has to be a limit on that as well, in order to ensure that these defections don't happen. And therefore a limit was imposed of 15% of the strength of the house. Council of ministers can only be 15% of the strength of the house. And the objective was to limit or create a disincentive for political defections by reducing the scope of the ministerial positions acting as an incentive or a lure. Did you understand? And this was not done by the 52nd Constitutional Amendment Act. This was done by the 91st Constitutional Amendment Act. That is why this particular provision becomes incorrect. The third provision becomes incorrect. Even though the objective is right, but the Constitutional Amendment Act given in the statement is wrong. What is it asking? Which of the given statements is or are incorrect is what we are asking. So the answer becomes 2 and 3 only. Yes, 2 and 3. I'll add this here to be 2 and 3. And therefore B is your answer. The incorrect statement becomes 2 and 3. Clear? Now let's come to our next topic, or let's write the important Constitutional Amendment Acts so that you have your mains enriching points. So some of the main Constitutional Amendment Acts. The first Constitutional Amendment Act, please tell me, of 1951, what was the particular important development? And this has been asked in a previous year question. One of the important developments was that a lot of land reform cases were happening. The state was taking up a lot of land reforms where land was taken by the zamindars or big lands because of land ceiling was imposed, and therefore land was taken beyond the ceiling limits and was redistributed in the weaker sections per se. And because of this, these particular acts of land reforms were challenged a lot, because a lot of petitions and cases were filed in the courts that these land reforms are violating my right to property per se, or my fundamental rights per se. And therefore the burden in the courts was increasing, and therefore what the parliament did to ensure a judicial scrutiny of certain acts, they created a ninth schedule. And all laws that were added to the ninth schedule were immune from judicial review, were immune from judicial scrutiny. That is the important part of the first Constitutional Amendment Act that you need to remember. Of course, it is not immune anymore because of the IR Coelho case. because of the IR Coelho case, it is now subject to judicial review. Yes. Now, second, the next important act that you need to remember is the 42nd Constitutional Amendment Act of 1976. Why is this important? This is important because it is also called the mini constitution. It amended the constitution to such a limit that it is called a mini constitution per se. What were the important parameters? What were the important points that were added in this same? The important points were added that the preamble was amended and the words socialist, the words secular, the words integrity were added to the preamble. Yes. Another part was a lot of DPSPs were added. For example, Article 39A, leading to free legal aid, was added as part of this. Article 48A, associated with environment protection, wildlife protection, were added. An important segment was added that was not part of the original constitution. What is that segment? It is Part 4A, that is fundamental duties. Fundamental duties was added. It was not part of the original constitution. Very, very important. Yes. What else? What else? The constitution of tribunals. Article 323A, Article 323B. You will do this later with Sarmat sir, so you do not have to worry. But these were the major highlights of the act. And also Article 74 was amended, and it said that it is important for the president. The president is bound by the aid and advice of the Council of Ministers. So whatever the Council of Ministers tell the president to do, he is bound to follow that particular advice. Therefore, can you see, this is a particular act towards strengthening the position of the executive or the legislature or the government of the day vis-a-vis the constitutional safeguards, to strengthen the same. Yes. 44th Constitutional Amendment, also very, very important. 44th Constitutional Amendment, the spirit was to restore certain constitutional safeguards, such as, we've already done Article 352. Article 352. Now, there are certain criterias on which a national emergency can be proclaimed. Earlier, before the 44th Constitutional Amendment Act, internal disturbance could be used as a criteria, could be used as a pretext to proclaim the emergency. Now, please understand, internal disturbance is a very vague term. It is subject to misuse. It is open to interpretation, and therefore it can be used as a pretext to apply president's rule. It can be used as a pretext to declare national emergency. What happens in national emergency? The central government gains a lot of powers as compared to the normal times of the constitution. It almost becomes a unitary structure where the center becomes very powerful as compared to the states. Yes. And therefore, to ensure that safeguards exist and prevent the center for using the pretext of emergency to gaining powers, therefore we needed this change in terminology, and therefore the 44th Constitutional Amendment said that only internal disturbance should not be a criteria. In fact, it should be changed, and a very specific criteria should be added, that is armed rebellion. So only if you know that certain developments have happened in the country which can be classified as citizens or any section of the population picking arms against the state, only then it can be used as a pretext to declare emergency. Yes. So one of the criterias which was vague earlier, that is internal disturbance, they wanted to ensure that this vagueness is particularly done away with, and this was replaced by armed rebellion. Yes, so this is in the nature of safeguards. The other example that we've already done in the MCQ is that you would not just proclaim emergency. The president will not just proclaim emergency on the words of the prime minister, the spoken words of the prime minister, but on the written advice of the cabinet, and that is where the cabinet as a word was introduced in the constitution. So written advice of the cabinet will be required for the president to proclaim an emergency. Yes, so this becomes important. The other facts also that you'll do when you are doing emergency is that it has to be ratified, not just proclaimed, but it has to be ratified by both houses, Lok Sabha and Rajya Sabha, by a special majority in 1 month's time, so that it has a democratic mandate also. Yes, the executive is taking the executive is accountable to the legislature, and the legislature is ratifying the need of a national emergency. That becomes important. It obviously also gave powers to the Lok Sabha to revoke the national emergency with a simple majority. Yes, so that it indefinitely does not go on, and Lok Sabha, which is the legislature representative of the people, that has an option to revoke as well. Yes, so this becomes an option. And another important fact that was introduced is that Article 19(1)(f), that was relating to the fundamental right of property, the right to hold property, which was earlier a fundamental right, was no more a fundamental right now, and it was made a legal right under Article 300A. Okay, so fundamental right to property, to holding property, this was particularly diluted under 19 subclause 1 subclause F, and it was now a legal right under Article 300A. So that's all that you need to remember with 44th Constitutional Amendment. The next important amendments, of course, are the 57th Constitutional Amendment of 1985. What was important in this? This was an important step for anti-defection. This was an important step for the 10th schedule. Yes, the 61st Constitutional Amendment Act of 1988, lowering the age to vote from 21 to 18. The next important constitutional amendment acts are 73rd and 74th, 1992, associated with decentralization of democracy. Yes, that means Panchayati Raj institutions and urban local bodies. The schedules 11 and 12 were also introduced, etc. Another important article is, or Constitutional Amendment Act is 101, very, very important, because this was the GST amendment. This is given as a classic example. The GST amendment of 101 that required the ratification of the state, the third type of amendment that we had recently done, was a classic example of cooperative federalism. What do you mean by cooperative federalism? A federal structure, a model of federalism where center is not in an adverse relationship with the states, where the states are not resisting a certain change in the governance apparatus of the country. A federal structure in which the states are in fact willing to give up some amount of their taxation, some amount of their taxing powers, to ensure one nation, one taxation. Yes, so the center has cooperated, the states have cooperated with the center, they have given up certain amount of taxing powers, and therefore we could come up with a particular scheme or a mechanism where we ensure one nation, one taxation. So classic example of cooperative federalism. Yes, not competitive federalism or confrontational federalism. Confrontational means that they're confronting each other. They are opposing each other's moves. They are not cooperating with each other. And cooperating is that you are willing to do the same. The last, which was also asked, the 106th Constitutional Amendment 2023 was asked this year in your prelims as well. What was this about? 33% reservation for women both in the parliament as well as the state legislatures. Very, very important in that regard. Yes, so these are the important predominant constitutional amendments that you can write if there is a question on amendments per se. What is the procedure for amendment? We have done. Should parliament have the power because it is democratically elected body? We have done. Should parliament's power be restricted? Should it be curtailed to some limit? Why is there a need to restrict it? We have done. What are the important examples of the constitutional amendments? We have done. So this theme after this is over. I hope you have understood this particular section. Let's move to our next topic. But before that, we'll do a MCQ question. Okay? I'll see the comment section now. Consider the following statements. Dr. B.R. Ambedkar attended all the 3 roundtable conferences in London. Dr. B.R. Ambedkar set up the Bahishkrit Hitkarni Sabha. Dr. B.R. Ambedkar was the chairman of the drafting committee of the Constituent Assembly and was the first finance minister of independent India. I would see the comment section. I'd request all of you to engage, please. All right, let's discuss this. So Dr. B.R. Ambedkar attended all the 3 roundtable conferences that were held to discuss the constitutional advancement for India in London by the mother country being UK. So these roundtable conferences were held to discuss how we will proceed further in terms of constitutional advancement, what laws should govern India, what should be the governance machinery, should there be a federal structure, so on and so forth. And of course, as we know, the culmination of these roundtable conferences had led to an important act through which an important act, that is the 1935 Government of India Act, and our constitution derives a lot from that 1935 Government of India Act. Okay, so this is absolutely correct that B.R. Ambedkar attended all the 3 roundtable conferences. But if they asked you about Mahatma Gandhi, please understand, if they have the same statement for Mahatma Gandhi, please note that he did not attend all 3 conferences, roundtable conferences. In fact, the first roundtable conference we had boycotted as well. Yes, so this becomes important in that context. Second, Dr. B.R. Ambedkar set up the Bahishkrit Hitkarni Sabha. This is absolutely important. It is for the empowerment or working for the vulnerable or the downtrodden sections such as the Harijans, such as the scheduled castes, etc. And that is why the second statement is important. UPSC does have a tendency of asking in the prelim stage of the examination the organization, the body, and who is the responsible founder, who is the respective founder of the same. Specifically with personalities such as Dr. Ambedkar, it becomes important. So Bahishkrit Hitkarni Sabha is the founder or the person who set this up is Dr. Ambedkar. The third, B.R. Ambedkar was the chairman of the drafting committee of the Constituent Assembly. Absolutely right. But he was not the first finance minister. He was the first law minister of independent India. So first law minister of independent India, and that is why the third statement becomes incorrect. The answer is 1 and 2 only, and it is B. Clear? Let's move to our third topic now and see what all we have already done. What we have already done in this lecture are these two topics, judiciary's role and amendments per se for GS2. Let's come to the third topic now, that is role of the Indian Constitution in promoting social justice. A beautiful topic per se. Just stay with me. You will absolutely enjoy this. Now, is this important for us in the context of a syllabus? In GS paper 2, a direct syllabus topic is given which says the constitutional provisions, the laws, the schemes and the policies for upliftment of the vulnerable sections. If this wording is not absolutely directly pointed at the topic, I do not know what will. Yes? So, what are the constitutional provisions? What are the laws? What are the schemes? And what are the policies for vulnerable sections? That is your topic that is given. This specific emphasis for the vulnerable sections, affirmative action for the vulnerable section, specific focus and special treatment of the vulnerable section is nothing but social justice. So this topic is absolutely, in fact, a question can directly be lifted from here and be asked in the mains examination. In fact, even I think the previous year or in the last 2 years, there has been a PYQ question. There has been a mains PYQ question that says that policies and laws for the vulnerable sections are discriminatory in their very approach. That was a direct PYQ. Again, necessitating information or understanding of how the constitution is ensured that they are given certain type of special treatment per se. Yes, let's discuss this in a lot more detail now. Now, let's go. So this particular topic that we are doing is the role of the constitution to achieve or ensure social justice. Let's first understand what is social justice. Okay? So let's first understand what is social justice. Is social justice mentioned anywhere in your constitution? Social justice is written in your preamble, that we seek to achieve justice, social, economic, political. In fact, in the chronology, in the order that is followed in the preamble, social justice is mentioned first of what we seek to achieve with this constitution. So let's understand what is social justice. To understand what is social justice, let's understand what is social injustice. So when you talk about social, it means the injustice that is created due to the society, the discrimination that is created by the society, the lack of opportunities and hierarchies made by the society, the lack of opportunities given by the society, the inequalities created by the society. So because the society is perpetuating injustice, that is why we need social justice. So we can understand this as the society perpetuating means they are inflicting that injustice on fellow citizens. Society perpetuating or inflicting injustice. How does the society do that? Let's understand how does the society do that. The society does this by following certain hierarchies in a society. Caste-based hierarchies, once employed in our day-to-day interactions, can limit the kind of jobs that a person can seek. Caste-based hierarchies in the previous times has ensured forced labor, has ensured that certain categories of individual sections of the population are just engaged in menial jobs. That is why we have a huge connection between the scheduled caste and the number of people engaged as manual scavengers till very long. Yes. So because the society has created certain hierarchies, the society is denying participation, equal participation. The society is discriminating. For example, women, because of the patriarchal nature of the society, are denied equal wages for equal amount of work. They are denied opportunities in the leadership roles, and therefore we say a glass ceiling exists. Yes. So because of this, denying participation or discriminating, the society is discriminating. Yes. The society is exploiting a lot of children because they are vulnerable. Their child labor is exploited per se, which is of course banned now. Yes. And because of this, we see that there are grave inequalities. There are grave inequalities that are hindering the participation of these sections in the society per se. So these are issues or injustices that are perpetuated or inflicted by fellow citizens, by the society that we live in, and that is social injustice. First understand social injustice and then I will come to social justice. Did you understand? So hierarchy on the basis of caste, denied participation may be example of gender, exploitation may be relating to children, inequalities or denial of resources, for example, tribals. Yes. So these are vulnerable sections which are at a disadvantage. Please understand, that is the word. They are at a disadvantage because of society's treatment towards them. And that is why we call it social injustice. Yes. So society's treatment is keeping them at a disadvantage. Yes. So if we leave this to the society to treat, if we leave this to the society to reform by itself, do you think reforms will happen automatically? Do you think the state or the government of the day or the constitution should be a mere spectator of any kind of injustice happening in front of it? It cannot be the case. And therefore, when society is creating these disadvantages, these disabilities, that is when the state has to fill in the gap. That is when the constitution has to be strong enough to ensure that it is achieving social justice. Did you understand? So first understand social injustice. Who is creating that injustice? Society. So if society is creating the injustice, social justice becomes the responsibility of the constitution makers and the state. That means the legislature and the executive and the judiciary. All three organs are responsible for ensuring social justice is achieved. The constitution is responsible for ensuring that social justice is achieved. The historical inequalities, if we do not intervene, if the constitution does not have special provisions, if the state does not have specific schemes, if the state does not have reservations, do you think if they are already at a disadvantage, will they be able to compete with the other sections of the population? The answer is no. A special treatment is required to bring them at par with the other sections and then allow them to compete. allowing or expecting them to compete at an already disadvantage will be unjust, will not be fair. It will be against the concept of equal protection of laws. Yes, so that is why it becomes important in that regard. So who ensures social justice? It is the state's responsibility. It is the constitution's responsibility. Yes. Now let's talk about what do you mean by social justice. By social justice, you will ensure that there is equitable distribution, equity in the opportunities that a person gets, in the resources that a person gets, and the privileges that a person enjoys in a society. If you do not enjoy, now opportunity is a simple example. If there is a scheduled caste child who is suffering, whose family has been suffering from the problem of untouchability, who have been victims of untouchability for so long, that child was denied school because he was bullied in school. The child was denied school because his family was into forced labor and he had to continue serving the masters in order to repay the debt the family is in. That child is denied education because of the caste that he's coming from. That is a discrimination. That is a disadvantage that the society is creating when it comes to equal chances, when it comes to equal opportunities. If he was denied that equal opportunity, it is the responsibility of the center or the state or the constitution to ensure that certain special treatment is given, certain incentive is given, so that they can also participate in educational attainment fully. Yes, therefore we have the option of, or we have the provision of reservation to ensure equal opportunities are given, equal treatment are given, equal opportunities for getting resources are given. Yes, so this becomes important. Let's understand now. Yes, let's understand now that this is a beautiful argument. What are the two types of constitutions? One is a liberal constitution and one is a transformative constitutionalism. Please listen to me very carefully. It's a beautiful topic. So there are two types of constitutionalisms. One is liberal and one is transformative. It's important to understand how the constitution has played a role in ensuring social justice. Liberal constitutions are the constitutions in which the focus is only on protecting basic civil liberties of an individual, protecting the individual against the arbitrary power of the state. So there's civil liberties such as right to speech, there's civil liberties such as freedom of religion, there's civic liberties such as a right to, for example, right to property, etc. Basic rights which are against the state, which are in the form of civic liberties, are protected. So individual rights are the focus. Individual rights are the focus. Yes. So the objective of the liberal constitutions is to simply protect individual rights. The example are civic liberties such as freedom of speech and expression, generally against the state. That is the only criteria, that is the only agenda of a constitution to be in place. For a transformative constitution, this protection is just the bare minimum. This protection is just the basic that it wants to do. Yes. So this is, they want to have legal protections. They want to protect the rights of individuals. But the goals of a transformative constitution, as the word suggests, are way more ambitious, are way more. Using this constitution, in transformative constitutions, they want to change. The idea is to change the political, the social and the economic landscape of a society. the political, social and economic landscape of a society. They want to ensure that we go beyond the political rights. What are civic liberties are political rights. That you have the right to equality, you have the right to vote, you have the right to freedom of speech and expression. These liberal constitutions, they are just protecting the political rights of the citizens against the state. While transformative constitutions want to touch upon every aspect of a person's life. They want to ensure that there is social equity as well. There are lesser economic inequalities as well. There is social justice, there is political justice, and there is economic justice as well. Rights in the transformative constitution are just the bare minimum. They want to go beyond it. They want to make changes even in the society per se. Yes, in the liberal constitutions, the idea is that the role of the state is limited. Role of the state is limited. In fact, the state will be at an arm's length from a person's day-to-day life. The state will not intervene in different areas. So the role of the state is limited. While in transformative constitution, now please understand, to transform anything, you will definitely have to take a more active role. You will have to intervene a lot. And therefore, in transformative constitution, the state's role is extremely active. It is willing to intervene, to bring about social change, to bring about political change, to bring about economic change, to reduce injustice in a society, to bring about social justice in a society. Yes, so that is why you need the state to intervene. Next example is in the liberal constitution, the rights are generally negative in nature. What do you mean by negative in nature? It will just protect you against the state, the arbitrary actions of the state. Versus in the transformative constitution, the idea of the constitution is not bare minimum protection, but it is empowering. What do you mean by empowering? That the constitution will not just give you basic rights against the state, but the constitution will ensure certain affirmative action, will have certain reservations, for example, special treatment for certain sections to bring them at par with the others and ensure true justice. So, empowering related provisions are also part of this kind of a constitution. Yes, so empowering or affirmative action, example being reservations. What else? Do we also see a change in the models of secularism? Have you heard about the context of the Western model of secularism being different from the Indian model of secularism? It is based on the same kind of argument. In liberal constitutions, the state will not intervene. The state will be at arm's length from any religious matter. Whatever is part of your religious group, whatever is part of your religious doctrines, the state will not intervene in that kind of a context. The state as well as religion have nothing to do with each other. It is a watertight distinction per se in the Western models in the liberal constitutions. But in the transformative constitutions, what we witnessed was that a lot of injustice is done in the name of religion. A lot of social evils are perpetuating in the name of religion. A lot of regressive practices are going on in the name of religion. And therefore, the state could not sit like a mere spectator, but had to intervene to bring about certain changes. And therefore, the Indian model of secularism is one where the state can intervene to restrict religious freedom, and to restrict religious practices if they are if they are violating the fundamental rights of an individual, if they are regressive per se. An example is sati. An example is sati. An example is instant triple talaq. Yes. So the state stepped in. The state stepped in, the judiciary interpreted it in such a way that we banned a certain practice even though it is particularly followed in a particular religion, in the personal laws of a particular religion, but because it is against gender justice, therefore we intervene. This is a classic example of a transformative constitution. A liberal constitution, the scheme of things, the type of governments is that they will not intervene per se. Yes. Another example or another feature of liberal constitution is that they will also believe in economic liberalism. What do you mean by economic liberalism? That they will say that the state, or we do not care about inequalities in the society, we do not intend to bring about an inclusive growth, we will leave it to the market forces. We will leave it to the market forces and an individual's effort, and therefore follow what is called the laissez-faire policy. They will not, in a way, they will not ensure any kind of special schemes, special assistance, certain social security measures, etc. for the downtrodden sections, for the vulnerable sections, etc. While a transformative state will ensure or will try to bring about certain economic redistribution, will try to ensure inclusive growth. An example is land reforms. An example is progressive taxation. So that is how we have, absolutely. So this example, the liberal constitution example becomes USA, while the transformative constitution example become India. So liberal constitutions do not participate so much to bring about changes in the society. They simply protect the individuals against the state, while transformative constitutions such as India go well beyond their scope of just being a bill of rights. In fact, they make sure that they have, for example, our DPSPs, Directive Policies of State Policy, have a lot of certain provisions which are directing the states to bring about social change, which are directing the state to take special efforts for the care of the downtrodden sections, the economically weaker sections, the scheduled caste, scheduled tribes, have certain provisions for maternity benefit, so on and so forth. Yes, so that is why transformative constitutions believe in state interventions to bring about change. As Granville Austin had particularly said, Granville Austin had quoted, he had particularly quoted that the Constitution is in fact a tool for bringing about a social revolution. Yes. So constitution is a tool to bring about social revolution. You can make changes only if your constitution is transformative in nature. Yes. And therefore we see that how has the constitution ensured social justice? By going beyond the ideals of legal equality and focusing on substantive equality. I will explain this statement, do not worry. Legal equality under Article 14 would mean that everyone is equal in the eyes of law. Equality before law is legal equality. Political equality only is legal equality. Substantive equality is one which is also taken into consideration social equality, political equality, and to some level also economic equality. So what we seek to achieve, what the Constitution seeks to achieve, is also equal protection of laws. Yes. And that is why this particular chasing substantive equality, the goal of substantive equality, is why we have affirmative action. That is why we have special treatment. That is why we have certain positive discrimination for those sections that have been victims of historical injustice. Yes, so that is why we have to bring about fairness, to reduce the injustice, to overturn the historical wrongs. What we have is affirmative actions. Affirmative actions means that we will positively discriminate, not negatively, positively discriminate for those sections that are more in need of attention. Yes, so example, reservations in educational institutions and reservations in jobs, etc., for the downtrodden. Yes, next, the constitution has also ensured the respect for diversity. How has that been the case? How have we respected diversity? For example, when it was interpreted by the judiciary in the Navteej Singh Johar case, we are upholding the rights of the LGBTQIA section, extremely discriminated section, respect for diversity, diversity of sexual inclination as well. Yes, another example of this is by ensuring universal adult suffrage. What does this mean? That you have given, please understand, voting or giving the power to vote can have a huge transformative potential for a certain section of the population. The moment you are seen as a political vote bank, the moment you are in a way deciding the future of the politicians, you are deciding who will form the government, you have been given the power. Your voices have been amplified, and therefore in India where we decided that we'll be giving universal adult suffrage or universal adult franchise without any kind of criteria for literacy, for economic, for property, any other criteria. We will be allowing everyone to have a voice. We will be giving everyone the voice and amplifying their voice. This is also an aspect of increasing or amplifying voices and helping in mobilizing the vulnerable sections. Another example of how fundamental rights. Please understand, we are a constitution, transformative constitutions. In liberal constitutions, you've generally seen that the rights are against the state. The state's arbitrary powers are protected. So you are protected against the state. In transformative constitution, they took into consideration the social reality. And they said that we do not just have to protect the citizens or individuals against the state. We also have to protect them against the fellow citizens, against the society that is discrimination, against the society that is leading to a creating or perpetuating certain regressive practices. And therefore our fundamental rights, few of our fundamental rights are not just against the state, they are also against fellow citizens. They cannot discriminate against a vulnerable sections. Yes, so that is an example of a transformative constitution as well. So fundamental rights against the state, but we are going beyond that. We have certain rights even against the society's treatment. What are the examples? What are the examples? Absolutely. Article 17, banning untouchability, is not just against the state. Of course, the state will not do it, but it is also against the individuals in the society. Yes, and that is why we have the atrocities, prevention of atrocities against SC/ST Act. The other example, yes, the other example are Article 15, subclause 2. The right against discrimination. You cannot discriminate against an individual. You cannot stop them from accessing public places. For example, in historical times, a lot of scheduled caste people from the lower castes were stopped. They were denied access to wells, to shops, to temples, so on and so forth. And therefore, Article 15, subclause 2. Article 23, forced labor. Yes, that you cannot employ someone for forced labor or forced means. Yes, so these are examples, and that is why our constitution is particularly focusing or going beyond basic rights as well. Yes, another example of this is that we are not just protecting the rights of the individual, but we are protecting the rights of minority groups as well. Minority groups as well. For example, Article 29 and Article 30, protecting the cultural and educational rights of the minority as well. Yes. So a constitution that is not associated, not only concerned with individual rights, but also the rights of certain sections that might be discriminated against. Yes, of course, DPSPs are an example of constitution guiding certain guidelines for the states to govern in the future. What laws, the guidelines for what laws should be made in the future, on what principles the laws should be made in the future, are enshrined in the DPSP. Example being Article 46. The state should endeavor to provide for economic and educational support for the vulnerable sections, for the downtrodden sections as well. Yes, so that becomes an example as well. Last but not the least, the judiciary's role. Judiciary's role you can write from the first topic that we had done, the LGBTQIA judgment, the Navteej Singh Johar judgment. Yes, and we can also talk about triple talaq. So that becomes a whole and whole answer on how has the constitution been a tool for social justice, for social revolution. Please understand, why is this the case? Why did India, just a thought, why did India adopt a transformative constitution per se? We adopted a transformative constitution because of our social realities, the prevalence of illiteracy, the prevalence of discrimination, the evils of the caste system, the previous instances of communalism in the form of communal rights, etc., hampering or creating a detrimental impact on the social fabric, on the secular fabric. Yes, because of all these concerns which were our reality. Yes, the fears of the minority against the majority, which is why the constitution had to be so exhaustive, which is why the constitution had to be diving into not just rights but other areas, which is why the state took up the responsibility for maybe reservations, so on and so forth. Yes, so those were our reality, and that is why we needed a constitution that was transformative and not liberal. Again, an argument that you can make. Did you understand? Yes. So this was one topic. It's done. We'll come to our last topic, but before that, I need you to attempt this question. Consider the following statements. Please attempt this question and we'll come to our last topic. just simple facts about the constitution becomes important sometimes because they asked about the historical underpinnings of the constitution and prelims as well. Please attempt this. Okay. Consider the following statements. The original constitution was handwritten by Nandalal Bose in the flowing italics style. Yes? Is this correct? The first statement is incorrect. The original constitution was first written by Prem Bihari Raizada. Prem Bihari Raizada, which is why the first statement becomes incorrect. Second, the pages of the original constitution were decorated. They were decorated by the artists of Shantiniketan from West Bengal. Shantiniketan and Nandalal Bose. So here the part of decoration is associated with artists of Shantiniketan and Nandalal Bose, not the calligraphy part, not the handwriting part. That was associated with Prem Bihari Raizada. Clear? So second statement becomes absolutely correct. Third statement, very, very important. The preamble of the constitution has only been amended once. Is this correct? We just did it. This is absolutely correct. It was only amended in the 42nd Constitutional Amendment Act, where socialist, secular, the word socialist, secular and integrity were added to the preamble. It has only been amended once, and that is why third statement is correct. So your answer becomes B, 2 and 3 only. Let's discuss our last topic and then we will wrap it up. Last topic. You have technological advancements here. Technological advancements. And you have laws and regulations here. The problem is that technology is changing by the hour. Technology is developing by the hour. The complexity of technology is also changing by the hour. Are laws keeping up with that change? Or is the development of technology outpacing the change in laws? Did you understand the topic? That you have certain technologies, for example, the usage of artificial intelligence, for example, the usage of Internet of Things, for example, the usage of predictive analysis, cloud computing, so on and so forth. So on one side, you have technology which is growing at a very, very rapid pace. And on the other hand, being a country, you need to also have laws, you also need to have regulations to govern those technological aspects, to regulate the use of that technology so that it is not misused, so that citizens' rights are protected, so that technology is used in the right manner for the right intention. So regulation is important. For regulation, you must have a law in place that is governing that technology. So what the consideration in this particular topic is technology developing at such a fast pace that laws or the policies are not being able to keep pace with it. They are not able to catch up with the development. And that is why we have regulatory gaps. That is why we have gaps in governance. That is why we have certain loopholes that can be misused. And this becomes a concern for us. Why is this important? This becomes important even in GS paper 2. Even in GS paper 3, this year they had asked that a question was on Data Protection Act. It is nothing but a law regulating new age concepts such as data. How will data be managed? How will data be stored? What are the concepts of consent when it comes to data? What are the rights of the individuals? What are the rights of the processing entities? So on and so forth. So that's a new avenue of regulation, new domain of regulation. And this keeps changing because technology changes very fast. and therefore governance related challenges can either be asked in GS paper 2 or GS paper 3. This is something that you must at least have a basic idea about. So we'll do a basic analysis of this, and then we will dive into the last topic. So here is regulation is becoming a challenge, or there are gaps in policies or gaps in regulation. This is the theme particularly. I have given you the previous year question, the Data Protection Act. Clear? First things first, the first argument that you will write is that the pace of innovation, same thing, the pace or the speed of innovation in the technology landscape, in the technology ecosystem is way fast, is way quicker than the pace at which laws can be framed. Here, because of innovation, there is a lot of advancements in AI, in robotics, in cloud computing, etc. But laws require a lot of deliberation, laws require a lot of consensus, and require a lot of discussion to be formulated. And once a law is made, it will require a lot of discussion to further keep amending the same. And therefore, there is a mismatch in terms of the pace. So, first problem. The second problem is the remote nature of technologies today. So, the technologies operate in no physical jurisdiction per se. So, for example, there is data that is stored in a different country, and you are in a way ensuring or regulating the usage of data here in the national borders of India. Yes. So how would you have the jurisdiction over the usage of Indian data in maybe a different country? If there is a server of a particular company using that data for AI, but that server is not in the national boundaries, the physical national boundaries, how would you check those jurisdictional problems? Yes. So this becomes a problem, that is the remote nature of technology. The non-physical or the non-tangible nature of technology makes it very, very difficult in the context of fixing a jurisdiction per se. It also makes it difficult in the context of cooperation. Laws will not be effective until and unless you have an international collaboration or cooperation, that other countries also are recognizing certain similar kind of restrictions, regulations per se. Yes, so that is why the remote nature can create problems of jurisdiction, can create a problem of international cooperation, and therefore can make the laws or the regulations less effective per se. Yes, so it is generally transcending borders. Next particular problem is that when you are trying to regulate, for example, there is a crime that is committed, when you are trying to find evidence for the same, any kind of law, any kind of evidence act can rely on forensics, can rely on physical evidence per se. But when it comes to technology, you will also have to make changes to your evidence act to ensure that digital forensics or digital footprints can be admissible as evidences in a court of law, helping in criminal justice system. That also becomes a complex channel. Yes, so digital footprints, etc., or searches now will be having to create new evidence requirements. That will be complicated. Yes, the next aspect of this is that because technology is changing, with that what happens is that the laws that are already in place they all also are becoming redundant. For example, you can ensure that labor laws are followed in a space which is a physical setup, a physical factory setup, employing a certain number of people, certain formal agreements, so on and so forth. But with the advent of technology such as the Uber, Ola, Urban Clap, so on and so forth, what we see is that a lot of gig workers are coming up. Yes, and therefore the labor laws which could be applied in a normal physical working space no more can be employed here. Who checks the responsibility of a work done by an AI computer? Who checks the responsibility? When you talk about industrial disputes also between the workers and the management, who takes the responsibility of the mistakes or the errors made by AI? So those are aspects also that it is circumventing traditional laws. Example, the use of technology for gig workers. And therefore your social security codes or labor codes become ineffective. Yes or no? Yes. Next aspect of it. Next aspect of it is when you are trying to regulate technology, you will always be creating a balance. You will always suffer the problem. There will always be a issue of if you want to restrict it totally, if you want to be a little harsh in terms of restrictions or not, because most technologies can be used in a dual purpose. It is the intent with which you are using the technology that decides the outcome of the usage. So the dual use means that AI can be used. AI can be used both by the terrorists, so you want to restrict the usage of it, while AI can also be used by the law enforcement agencies for doing their predictive analysis. It's called profiling. Yes? So there is a dual use of technology. How will you make sure that it is restricted so that it cannot be used by the sections wanting to use it for a bad purpose? And how do you allow it to be used for advancement of the society? So how much to regulate or the degree of regulation will always be a issue, will always be a question mark in order to not curb the usage for advancement of the society. So degree of regulation will always be a problem. Next aspect of it is the delicate balance. The same thing that I told you, the delicate balance, so that it is used in the advancement of the society as well as privacy. So next topic becomes, how do you make sure that privacy of individuals is protected? A lot of technologies nowadays is built on data as their gold, as their fuel per se. So privacy concerns become very, very important in that context. That how do you allow for companies to continuously use data to ensure advancement in technology, but also ensure the rights of individuals are protected per se? Yes. Next problem when it comes to technology is the internal security problem. What is the internal security problem? That a lot of internal security, for example, acts are committed using the technology. For example, the easiest way to commit money laundering, the offense of money laundering, is by using anonymous ledgers, is by using technologies such as blockchain. For example, using technologies such as cryptocurrencies. Yes, so that the transactions are anonymous in nature. The person who is ensuring or initiating these transactions is not known. So this also creates an internal security problem per se. The anonymity created by these technologies becomes a problem that can destabilize economy, that can destabilize the country. Yes, another important fact of technology is that when you talk about social media, When you talk about social media, how do you have certain regulations? Have you heard about the IT Act, etc., the Social Media Act, etc.? How do you have regulations to create a balance between what people can use or their speech and expression, as well as preventing hate crimes or preventing any kind of fake news to develop? Yes, so that becomes a problem as well. Last but not the least, safeguards for the states. What does this mean? That the state, for example, in the UK, what it is that the UK security agencies or law enforcement agencies use the AI for profiling. Profiling means that they are following your activity, your data usage, your online activity to predict. For example, they do it for children. So if children are giving away a lot of their personal information to a stranger, if children are again and again trying to use a website which is maybe relating to a racket which is relating to child abuse or which is relating to child trafficking, okay, so with this kind of data usage, what they can do is they can predict if that child is vulnerable to such a crime against him or not. That is profiling. Yes, for example, how you have your ads whenever you're searching anything on the internet, suddenly on Instagram, etc., you start getting these ads that if you want to buy the same thing, so these ads start cropping up. That is nothing but profiling. They are using your data to analyze or predict your choices. Yes, so it is important. Sometimes it can be used by the state, by the law enforcement agencies of the state. So AI can be used for predictive policy. Example in UK. But how will you make sure? And this is a little bit of a dilemma when you're regulating technology. How will you make sure that the state does it in all the truest intention? How will you make sure that the state might not use this power to surveillance? Yes. So a delicate balance has to be made even while allowing the state to use certain technological tools per se against the citizens. Last but not the least, ethical concerns. What do you mean by ethical concerns? How you are using the technology. For example, biotechnology or gene editing methods. Have you heard about the gene editing tool called CRISPR? CRISPR-9? Cas9, CRISPR, etc. So are you using the gene editing tool? We should not completely ban gene editing because it is being used a lot for, in a way, helping in genetic disorders per se. For treating genetic disorders, very, very traumatic genetic disorders per se. But the same tool can be used to manipulate life and be used for designer babies. Babies which will particularly have certain already decided characteristics and features. So this becomes an ethical concern, that how much are you intervening? How much are you interfering with the basic biological process of life per se? Yes, so these are ethical concerns when it comes to biotechnology as well. Of course, there are others. For example, GM crops can be an example for ensuring food security. But GM crops can also have environmental concern in the context of the harm to biodiversity. Yes, so that also becomes important. Yes, so that becomes important. So this was the last topic. Yes, biohacking as well. Absolutely. So here you can write about the things. So that is all that we are understood from this topic. What I'll do is, since we've overshot our time, it's a simple mains enrichment point, the BNS impact. I will write it at the final PDF and I'll upload it so that you do not have a problem. So the last point of the impact of BNS is nothing. It is just a simple discussion of what are the new offenses, What are some of the new features that have been added in the BNS? Is there a change in the way we see justice? Because earlier IPC, Penal Code, was specifically focusing on punishment, but Bharatiya Nyaya Sanhita is focusing on Nyaya, which means justice. So that is just simple things that we will do as mains enrichment. I will add it in the PDF that I'm uploading. I'll not take more time. Yes. Is this okay? I wanted to check in the comment section. Please tell me in the comment section, or would you want me to explain that? Would you want me to explain that as well? All right. Alright, so with this we've come to an end for today's video. This is all that you need from Yojana of the month of November. There's nothing more that you need. In fact, the chapters were giving very, very little information per se. I have added more information and I've made sure that you're going back after preparing certain themes that are absolutely relevant for the exam. I hope you take back something important from this video. Thank you so much for your time and patience. Please make sure that you shower your love in the form of likes, sharing the video, commenting on it, and of course subscribing to the platform, because we'll be coming up with a lot more videos in the coming months. Thank you so much. Have a wonderful, wonderful evening, and I will see you again very soon. Bye-bye.